Have you ever wondered if having a criminal record means you can still visit, work, or study in Canada? I am Faiz Khan. I'm a criminal defense lawyer in Toronto, and today I'll walk you through what the law says and what really happens at the border. I often get questions from my clients that can foreign nationals with a Canadian criminal record visit, work, or study in Canada? So, foreign nationals, people who are not Canadian citizens or permanent residents, they often want to come to Canada, whether it be temporarily or to work, study, or visit, or permanently with the hope of becoming permanent residents and eventually citizens here in Canada. But here's the critical point: it doesn't matter if the crime was committed here in Canada or abroad, whether you need a visa or you don't need. In most cases, a criminal record makes you inadmissible. Let me explain the process to you. If you need a visa, you'll apply at a Canadian embassy or consulate. You must disclose your record. You must provide record and police documentation, and an immigration officer will decide whether you'll get a visa or not. If they find you inadmissible, your visa is denied. If you don't need a visa, on the other hand, say for example an American citizen, you are automatically applying at the border. Immigration officers will check your documents, they'll run computer searches, and then they'll ask you questions. If flagged because of an outstanding warrant, a past record, or say for example something, you say you'll face further questioning, in that situation, what happens? So the Immigration and Refugee Protection Act states that you are inadmissible if you are convicted of, number one, in Canada, number one, of a federal offense which is punishable by at least 10 years. So number one is this. Number two is you are convicted of any indictable offense in Canada. Number three is you. Number three is like a federal offense which carries a jail term of 6 months or more. So if you're convicted of a federal offense which gives you a jail term of like say 8 months, you cannot come to Canada. And there's the fourth situation, whereas it says that if you face two separate federal offenses, if you're convicted for two separate federal offenses, you cannot come to Canada. But many a times, like, I get questions from my clients. Say for example, if somebody was convicted of committing fraud below 5,000, in that case the punishment, if you get it for less than 6 months, no problem, you are free to come to Canada. But sometimes even summary convictions, the least serious type, can cause problems, and they can count. Now, here's the truth: people are refused entry every day for records far less serious than the law suggests, right? And officers assess the entire application. If they see you a risk to public safety, they can deny entry. That means even a minor conviction can complicate delay or prevent you entry to Canada. The bottom line is a criminal record doesn't always end your Canadian plans, but it does make the process more complex, and much depends on a visa officer's discretion. That's why it's critical to get the right legal advice before you travel. I am Faiz Khan, a criminal defense lawyer in Toronto. If you or someone you know is worried about how a criminal record might affect entry into Canada, you can reach out to us. At Faiz and Associates Law, we are here to guide you through every step of the process. So stay informed, stay prepared, and I'll see you in the next video. Thank you, my friend. Have a good day.